welcome to Term Talk. I'm Shelly Easter, producer and education attorney at the Federal Judicial Center. In each 8 to 12 minute episode, we discuss the terms cases that are most likely to impact the lower courts. With me today is Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at UC Berkeley Law School, and Michael McConnell, former judge of the 10th Circuit, Francis and Mallery Professor of Law, and Director of the Stanford Constitutional Law Center at Stanford University Law School. Thank you both for being with us here today. Michael, let's talk about Allen v. Milligan. This case addressed whether race can be a consideration in the drawing of election districts. Can you get us started on this case, please?
So this case arises under the Voting Rights Act of 1965 as it was amended in the 1980s. And the act allows plaintiffs to challenge election maps. There are also other types of state law, but this particular case has to do with maps on the ground that they do not allow minority voters the equal opportunity to elect representatives of their choice. The Supreme Court's dominant interpretation, really only interpretation of this, the 1986 decision, Thornburg versus Gingles, which sets forth three prerequisites for bringing a suit of this kind, which have the most important one of which is political polarization. And with those three prerequisites are met, then the three-judge district court applies a, quote, totality of the circumstances test to determine whether the minority voters, in fact, have been given such an opportunity. That usually hinges upon, some comparison of the map to possible alternatives drawn up by the plaintiffs. Well, in Alabama, there are 7 districts, and the Black population of Alabama is about 27%, and the legislature drew a map which only had one district which would be likely to elect a minority candidate. The plaintiffs were able to draw up an alternative map with 2 Black-dominated districts, and importantly, their map also satisfied all of the race-neutral criteria of traditional districting. In fact, it may have even been better on the basis of some of those traditional principles. Those principles, it's very important to know what they are. They are basically compactness, so you don't have sprawling, lizard-like districts, and that of equal population, and minimizing the splitting of traditional political boundaries, such as county lines or city lines, and then finally, but secondarily, respecting traditional communities of interest. And so the district court had held that the Alabama map was violated the Voting Rights Act because it was this alternative did a better job in providing equal representation, but at the same time did not violate the traditional race-neutral criteria. And the Supreme Court affirmed in an opinion by Chief Justice Roberts that I think essentially leaves the interpretation of the Voting Rights Act as it was before and made no significant change.
So Erwin, can you take us to the arguments, please?
Alabama's argument was a radical one. It essentially said that the 1982 amendments to the Voting Rights Act were unconstitutional. Congress amended the Voting Rights Act to make clear that proof of racially disparate impact is sufficient for liability. There doesn't need proof of discriminatory intent. Alabama said that districting should have to be colorblind. Maps should be construed and configured in a race-neutral manner. And of course, Alabama also argued that it hadn't violated the Voting Rights Act. The Supreme Court rejects that argument. As Michael said, the Supreme Court uses the Thornburg versus Gingles test. The court notes while it was reasonable to split the Gulf Coast, the effect of that was to split the African-American community among the 3 districts. The court points out that the African-American community was sufficiently populous to elect an additional representative. It did point out that there is racially cohesive voting, and it noted that whites in Alabama rarely vote for Black candidates. Now, the court was clear it is not creating a requirement for racially proportionate representation, but it did say that under Thornburg versus Gingles, Alabama had violated the Voting Rights Act.
Michael, what are the takeaways from this case?
So the court drew a middle ground here, which I think has a lot of uncertainty, and for lower courts, it's going to be lower court decisions are necessarily going to be extremely fact-based. On the one hand, the court, I think, rather emphatically rejected the idea that there's any requirement in the Voting Rights Act of proportional representation, but it also said, and I think this is a key sentence from the opinion, let me quote it: "When it comes to considering race in the context of districting, we have made clear that there is a difference between being aware of racial considerations and being motivated by them." I think that's going to be a difficult line to draw. The main real constraint, a practical constraint on having maps dominated by race, I believe, after this case, is that the various race-neutral districting considerations, such as compactness and so forth, come first.
I don't think the court took a middle ground here. I think the court reaffirmed and applied the Thornburg versus Gingles test. And so the message to the lower courts is, when there's challenge to districting under Section 2 of the Voting Rights Act, that's what they have to apply. And I think it's also significant that the court rejected the idea that there has to be colorblindness, and that carries over beyond just the voting context. The only thing I'd say in looking to the future is about Justice Kavanaugh's concurring opinion. Remember, it's a 5-4 decision with him in the majority. And he said at some point, race consciousness must end. It's the same thing that he said in the affirmative action case, Students for Admission versus Harvard College. And perhaps that suggests there will be a point, maybe not in the distant future, where he might be willing to join the dissenters and overrule Thornburg versus Gingles, and maybe even invalidate disparate impact under Section 2 of the Voting Rights Act.
This does raise the interesting question of why the court came closer. It didn't. The Students for Fair Admissions did not adopt the pure colorblindness standard, but it came a lot closer than it does here. I think the question is why. I don't know the answer to that, but at least one possibility is that in the districting context, people are being the decisions are being made on the basis of demographic groups already. I mean, that's what the whole name of the game is in districting, is knowing what groups are likely to be going which way. And racial groups are politically salient. That hasn't happened as a result of somebody passing a law or a court deciding it. Racial groups are salient in politics because they are on the ground so important. And that may be why the court is less inclined to push against race consciousness in a process where maybe that's not even very possible.
Well, thank you both very much for being with us today. I look forward to talking with you again soon.